Well, it's Monday, and I just got back in the office after being out all day seeing clients in Pennsylvania and New Jersey. And with that said, I spoke to a client today who did retain us to represent him at trial. Our firm did not represent him at the preliminary hearing. And during our discussion, I was speaking to him and his family about what happened at the preliminary hearing. And it turns out that he actually waived his preliminary hearing. And in my opinion, he shouldn't have done that for several reasons. It's this case, not to get too far into it, but it's a case involving an illegal gun and some drugs, which our firm handles a lot of in Pennsylvania and New Jersey. But in this particular case, he waived the hearing and really didn't receive anything for waiving that hearing. He didn't receive some type of bail reduction or an agreement as far as bail. So his family ended up posting a considerable amount for his bail. In addition, there was no downgrading of any of the charges and certainly no dismissal of any of the charges. So I recommend to clients that if you're going to waive the preliminary hearing, the Commonwealth has to give you something in exchange for doing that, whether it be a consideration for some type of program or dismissing charges, downgrading charges, or an agreement in the bail. You have to receive something. There has to be some strategic reason why you're doing that. In addition, you have to understand that if you waive a preliminary hearing, while you're not prohibited from filing pretrial motions, you do limit the motions you can file. One of the big motions that you cannot file if you waive a preliminary hearing is a habeas motion, otherwise known as a motion to quash, which challenges the sufficiency of the evidence at that particular level, otherwise known as a prima facie burden of proof. So you don't want to do that again unless you're getting something in return. And there are reasons sometimes to waive a preliminary hearing. I know in the counties outside of Philadelphia in Pennsylvania, people often tell them that, you know, it's almost assumed that the DA's office assumes that you're going to waive the preliminary hearing. And your attorney should never go into a hearing just assuming that they're going to waive the hearing. Again, you have to receive something. Obviously, in New Jersey, they don't have the preliminary hearing system. There's the grand jury system, very different. I've done articles on that as well. But if you have questions about a preliminary hearing in Pennsylvania, our phone number, 215-755-9000 in Pennsylvania, 24 hours a day, 7 days a week. Our law firm's website, gambonellaw.com, a tremendous resource for you and your family. If you have a question about New Jersey and the criminal process there, 856-793-7429. Again, both these numbers are 24 hours a day, 7 days a week. I hope you're having a great Monday, and I will talk to you all soon.